Hi, I'm Dave Stiegel. I'm a shareholder at Lawton & Cates. I want to thank you for taking a couple moments to watch this video. Today I'm going to talk about and explain, if you're injured at work, why you should never accept the insurance company's denial of your claim without at least consulting with an attorney. As always, if there's anything I talk about these next couple minutes that sparks a question or you'd like to know how it may apply to your specific situation, feel free to contact me. You can either leave a comment through YouTube here, or you can contact me directly by phone or email. A link to my website with all that information is located in the description to this video. So the motivation for me making this video was that a couple days ago I read a statistic that it was estimated that about 80% of injured workers never contest the denial of their claim. And that made me almost fall out of my chair, frankly, because it's such a shame. So I thought I'd take 2 or 3 minutes here to explain why you should never do that, why you should always consult with an attorney. And I'm not just pumping the legal profession here. I'll explain to you when you should consider consulting with an attorney and how you'd go about actually hiring an attorney to represent you to pursue additional benefits. Okay, so let's get to it. Briefly, the work comp system is largely an insurance system. It's a compromise between employees and employers. So on the employee side, it's a no-fault system. It establishes benefits for loss of income, medical expenses, and other benefits. On the employer side, they get much more managed risk. There's no allotment for pain and suffering under workers' compensation. So they don't have to worry about having to pay large jury verdicts for pain and suffering primarily. Okay, so it's this bargain or this compromise between employers and employees. Now, when should you consider hiring or at least consulting with a workers' compensation attorney? That's at the time of a dispute. A dispute will arise when the insurance company denies your claim, or if that ever happens. But you'll know it when it happens because they'll send you something in writing that'll explain the reason why they're not going to pay your claim. They'll tell you the effective date of the denial, and then they'll include language that'll say something along the lines of, if you wish to appeal this decision, you have a right to file for a hearing before the Workers' Compensation Division. That'll be your cue that your claim has been denied, and that's the time you should consult with an attorney. An attorney before the claim's denied, or if your claim is never denied. I'm not saying that you should not consult with an attorney. There's a limited ability for an attorney to help you before there's a dispute. The way the law is developed is that it envisions an injured worker hiring an attorney at the time of dispute or in an attempt to obtain additional benefits beyond what the insurance company has already paid. Okay, so if you get a denial letter and your claim has been denied, that is the time you want to call around or try to consult with an attorney. Many attorneys, including the attorneys at our firm, provide free initial consultations, so there's no cost in at least talking to an attorney. And as I'll explain here momentarily, there's no downside in doing so. It doesn't cost you anything. Okay? So how would you go about doing it? I think embedded in that 80% of people that don't contest a claim is this mistaken belief that they can't afford an attorney to pursue their claim. And I want to encourage you to think of it the exact opposite way. I want you to think about it in terms of you can't afford not to hire an attorney to pursue additional benefits. And here's what I mean. Traditionally, if you hire an attorney, you find whatever attorney you think will do a good job, you strike whatever deal you strike with that attorney, and you're largely paying for legal services as they're performed for you, out of pocket. Under work comp, it's totally different. It's set by statute. So every attorney in Wisconsin should offer you primarily the same agreement, which is in Wisconsin, a work comp attorney only gets paid 20% of any benefits obtained on your behalf. So if you hire a work comp attorney and that attorney does not obtain any additional benefits for you, that attorney doesn't get paid. Okay, so here's how this works. On your end, you select an attorney that you think will provide you good service, that knows what he or she is doing, and most importantly, that you think will get the best possible outcome for you. All right? Under this agreement, your attorney's interest and your interest are aligned, which is to maximize or get you the most amount of benefits possible. So on your end, you don't pay anything out of pocket for your attorney's time or the costs that are needed to put your claim together. those are paid upfront or advanced by the law firm. If your claim settles with the insurance company through a compromise agreement, or if you or your attorney persuade a judge that you are entitled to additional benefits at a hearing, then at the end of the concluding order from the judge will allot attorney's fees to the attorney. It cannot be any higher than 20% of any additional benefits obtained. And then the judge allots reimbursement of the costs necessary to put the case together, and you get the balance. So real quick, for example, just using easy math, if an attorney obtained $10,000 worth of additional benefits for you, the judge would award the attorney $2,000 as an attorney's fee, regardless of the amount of time the attorney actually put on the case. So if the attorney spent $5,000 worth of time, but only obtains $2,000 worth of benefits, there's no difference. You don't owe the attorney the difference. The attorney can only collect on the fee awarded by the judge. So it would be $2,000. Let's say there was $200 in case expenses that would get reimbursed, and the balance would go to you, the injured worker. Okay. So your and your attorney's interests are aligned, which is to get the best possible outcome for you, which in terms of work comp oftentimes relates to the highest amount of money compensation. Okay, and if you don't recover any additional benefits, you don't owe your attorney anything for his or her time or for the case expenses that were necessary in putting the claim together. Okay, for that reason, if you find an attorney that'll give you initial free consultation and you have this contingent fee agreement where it doesn't cost you anything out of pocket to pursue additional benefits, you really need to take advantage of that and at least consult with an attorney to see if you have additional benefits to pursue, because otherwise the insurance company is just going to close your file and you're going to get nothing additional from them. You very likely work too hard, and work comp, no one necessarily gets rich off work comp, let's say it that way. So you should fight for every penny that you deserve. I hope that's helpful. If you have questions again about how this may apply to your specific situation, feel free to reach out to me. I'll be happy to talk to you. I have another colleague that I work with that practices in work comp, so one of us will be able to hopefully answer any questions that you may have. I appreciate your time and attention. Again, my name is Dave from Lawton & Cates. Thanks so much.